All right, ladies and gentlemen, a very good afternoon. My name is Gabriel Achai, and once again, I speak to you live from the East Africa Law Society House in Arusha, Tanzania. And on behalf of Secretariat, I would like to say welcome for yet another phenomenal discussion on this time mastering competition law and consumer protection, an area that is critical for us as legal practitioners in today's evolving market. Today, ladies and gentlemen, we'll explore core principles, practical insights, and emerging trends in this field. Our expert moderator will guide us through the essential fundamentals, helping us to navigate this subject of consumer and protection law with confidence. Now, as we dive into this very wonderful discussion, ladies and gentlemen, allow me to introduce Miss Bridget Namboze, who is the managing partner of B. Namboze Advocates, CM Advocates Uganda. She's a board member of the Uganda Investment Authority, a former head of Legal and Corporate Affairs at Gamch Group, a former senior associate at the mighty Katende Sempebwa and Company Advocates Lex Africa member firm. She is also an accomplished legal professional with over 13 years experience in corporate law, particularly in areas of financing, mergers, acquisitions, regulatory advisory, and real estate. She is a co-founder and managing partner of B. Namboze CM Advocates Uganda, one of the thriving law firms in Uganda, a board member, as I said, of Uganda Investment Authority, and a very highly sought after speaker and an advisor in the field of competition law, corporate and mergers and acquisitions, financing, and data protection. Uh, this afternoon, before I hand over to Bridget, I would like to inform you, ladies and gentlemen, that we are streaming live on YouTube, Facebook, and let's get tweeting. And let's use that hashtag competition law that will be shared in our chat section to popularize our webinar this afternoon. Housekeeping rules will be when our moderator, when you would like to share or speak, you'll be required to raise your hand, and our dear moderator will give you that opportunity to do so. So at this juncture, I would now hand over to you, Bridget, to take us away until 4 p.m. We are all yours. Karibu.
Asante sana. Thank you so much, Gabriel. As introduced, I won't repeat myself. In 2013, I set out to pursue greener pastures like most of us do. I went to do my Master's of Corporate Law at Cambridge University. One of the topics we studied was mergers and acquisitions, and we had the opportunity to look at the European Union merger regime in comparison with the US regime. As I returned back home, I was very excited. And to my surprise, there was the COMESA merger control regime that had just started in 2013. They later on put in place the regulations and guidelines in 2014. Unlike our colleagues, in Uganda, we did not have a Competition Act. We had a bill. Kenya at the time had the Competition Act of 2010, while Tanzania had the Fair Competition Act of 2003. The debates at the time were whether the COMESA would be a one-stop center or the national regulatory authorities would take charge. In Uganda, we're happy that wasn't one of our challenges. We're just happy to have an authority we would refer to during mergers and acquisitions. Ladies and gentlemen, I am glad to tell you that today, COMESA is fully operational and guiding us through the competition regime. Join me in welcoming Dr. Willard Mweba. He is the Chief Executive Officer of COMESA Competition Commission, which regulates competition and consumer protection in the common market. Dr. Mweba has over 18 years of experience in competition and consumer law enforcement, with wide experience in enforcing competition law at a regional and a national level, as well as in the development of competition and consumer protection laws, guidelines, operational manuals in COMESA member states and beyond. He has also held positions of Head of Mergers and Acquisition Division at the COMESA Competition Commission. And prior to that, he was the Director of Mergers and Monopolies at the Competition and Consumer Protection Commission in Zambia. He serves as a member of the United Nations Conference on Trade and Development Competition Training Center for the Middle East and African Advisory Board. Currently, he is actively involved in the development of competition laws in the Middle Eastern countries and the review of the implementation of the competition laws in insular economies under the umbrella of the International Chamber of Commerce. Dr. Mwemba has written extensively and is a guest lecturer on the subject of competition and consumer law at various universities in Africa and beyond. Mr. Mwemba holds several qualifications inter alia bachelor's degree with specialization in law and economics from the University of Zambia, a master's degree in European Union competition law from King's College London, and a PhD in competition law from the University of Cape Town. Dr. Mwemba, you are welcome to this panel. Please take us away. Doctor, kindly unmute.
I'm so sorry for that. I think I'm still living in the analog world. So, yeah, but I was saying thank you so much, Bridget, and thank you so much, Gabriel. Bridget, thank you for the nice words and that CV you've read for me. At some point, I was almost telling you that, Bridget, I'm sure the people now have heard what my name is. Let's get to the business. But thank you so very much, and may I also appreciate and thank yourselves for inviting the COMESA Competition Commission to be part of this very important event today. Now, I have a presentation PowerPoint that we've shared here. I want to beg that I do not go page by page in this PowerPoint. Why? The subject I've been given is quite broad, and I know we have a diverse group of participants who may be at different levels of understanding competition law. So I want to make it as simple as possible and probably as interactive as I can be, even if it's virtual. So we've given you the slides for your information, but I may not go through these slides page by page. So let me start. Bridget and participants, the most important question I would ask, or I would begin with, why is competition law important to lawyers? Why should competition law be important to lawyers? It is one of those fields of law that has been invaded by so many. In fact, economists sometimes have played a very prominent role in competition law. And why? Because unlike any other law, competition law may not be law so traditional as we understand other laws. It is law as it is applied to markets. It is an economic law. And that's why economists and related fields have also found space on this subject. But why is it important to lawyers? The simple answer is, number one, it is the law. Competition law, as the name itself suggests, is the law. So lawyers should take keen interest in any aspect of the law. Why should lawyers be interested in competition law? It is because lawyers should be part of a group of professionals that aspire to contribute to the development of their nations, the development of their regions, and beyond. Because a competition law is a business law that shapes economies, that shapes economic performance. It is an indispensable tool in the developmental agenda of nations. Competition laws have been seen to contribute to the development and growth of economies, and lawyers should be part of that, especially that what we are dealing with is the law. And thirdly, a little bit more controversial, is that it is a lucrative aspect of the law, Bridget. It is not so in our part of the world, it is not so old a field. It's a very new field. Most countries have had competition laws in the last less than 20 years. Among the oldest competition laws on the continent would be model competition laws, model, would be countries like Tunisia, Zambia, Zimbabwe. But all these have only had competition laws in the last 30 years. And a number of them came after that. Unlike in other countries like the US, where it was in 1889, Canada, 1890, the Europeans around the 1950s. It's a very new phenomenon for us. So it is still very lucrative in that it is not yet saturated. We deal with different transactions at the Commercial Competition Commission. And believe me, the most lawyers we're dealing with are from South Africa, which is not a COMESA member state, and beyond, even from Europe. And we are able to see the values of these transactions and the monies that these lawyers are making. COMESA lawyers should take keen interest in this because it is lucrative. There is money in it. And I think that should be stated. We move to the next aspect of my presentation, having attempted to inspire and motivate you on why you should be interested in competition law. It is the law. It contributes to economic development, and it gives lawyers an opportunity to be part of that economic and development and growth agenda. It is lucrative, simple. You should get motivated. Now, why competition? Competition is the reason why we need it is very simple. We need competition so that those that we are dealing with, and it's competition in the context of commerce, competition in the context of business. So we need competition among businesses so that they strive to outdo each other legitimately, not in an orthodox method, legitimately. And as they strive to outdo each other legitimately, they grow. How do they grow? They become more innovative so that they attract consumers to themselves and not the other businessman who will also be striving to do the same thing. Okay, they give much more choice to consumers, and then there's consumer satisfaction. And as you know, with a dissatisfied consumer or a disgruntled consumer, economies collapse. With a satisfied consumer who is willing to spend more because they have faith in the products that have been supplied, economies grow. And then consumers also have not just a choice, but better products. That is why we need competition. We need competition in the market so that businesses strive to outdo each other legitimately for the benefit of consumers in terms of lower prices for the goods and services, greater choice, greater innovation. And that is why today we have cutthroat competition between Samsung and the Apple phone. I've always spoken about this because iPhone and Samsung have been trying to outdo each other. They've ended up being very innovative to the benefit of who? To the benefit of us, the consumers, because now your phone is your doctor, your phone is your medical record, your phone is your children's school records, your phone is your bank, your phone is your health record in terms of exercises, your phone is your photo album or gallery, everything. That did not come as by accident. It's because there were two companies, or even more before others just collapsed like Nokia, that were trying to outdo each other in terms of impressing the consumer. And to impress the consumer, they kept on advancing and advancing and advancing. And that is what they have done to the betterment of us, the consumers, but also the general economy. The countries where they are coming from, these phones, Apple phone and Samsung, you can agree with me that they've contributed to the growth of those countries, the United States and South Korea. They've also contributed to the growth of our own economies in that the way we do commerce now, because of these smartphones, has changed. It's very easy now to transact within a second, unlike before. So as a result, we have ended up having greater efficiencies in business, which has also contributed to our commerce and our economic development. That is very important. The absence of competition results in what I may call cannibalism, business or market or commercial cannibalism. Okay, in that whenever you have one company existing, it will not care about the consumer because they know the consumers have no choice. Even if they are providing high prices, products at high prices. Their products are inferior. There is no choice. Their efficiencies are so gravely low. They are so inefficient. They will never care to improve on these aspects because in any case, the consumer has no choice. Now, that may appear as if the problem is just on the consumer, but the problem goes beyond that. The problem is also on our nations because those companies will refuse to grow. They have no incentive to do that. They are in the comfort zone. The consumer will not react to go to another. So they will refuse to grow. And where they do not grow, they will not employ more people because they are static. And where they do not employ more people, the government will not have raised more taxes from such companies. It is as simple and basic as that. And again, for lawyers, I would want to assure you that in most cases, people who practice competition law, like myself, have attempted to make it a very complicated subject. They've attempted to tell people that it's a very technical subject. You should not think like that. It is actually a very simple, basic subject, even if they may be using esoteric terms in certain instances. It is as simple as the pieces I'm joining together here. So, competition laws then come in to ensure that businesses do not engage in that cannibalism where they kill off other businesses so that they are the only ones that remain in the market. In the context of mergers and acquisitions, and I was so glad Bridget said she studied this at Cambridge and looked at comparisons between the system in Europe and the system in the US. Bridget, you should be very proud that you have that system in Africa. The Commercial Competition Commission to which you belong and Uganda belonging, I'll tell you that it is the only second fully functional competition authority in the world, and it's in Africa. So we should be very proud of that. And the things that you saw in Europe, those are the things that we are doing. So competition laws will come in to make sure that those businesses that are operating in the market do not end in cannibalism by killing others so that they are the only ones that remain in the market to exploit the consumers. In mergers and acquisitions terms, we call that killer acquisitions. And competition authorities are very careful. That's why they review mergers. Sometimes businesses, including yourselves as lawyers, because you've been informed by businesses, you come to tell competition authorities that they are just a hindrance in the way of business. Why should it take time for competition authorities to look at mergers and approve them? That is in it. The reason we do that is that because through those mergers and acquisitions, companies may use it as an approach, okay, or as a system to eliminate others so that they are the only ones that are remaining on the market, so that they exploit the consumer. So the competition authorities will look at that and make sure that those incentives or those motivations are not there. The motivations for a merger should be greater efficiency, should be better products, should be lower prices, and probably wider choices. Once competition authorities are very sure that those things you are seeing on the screen are what will arise from the merger, then they let it go. However, if they are of the view that none of these things will arise from the merger, they would realize that this is just a form of cannibalism who make sure that only one company survives in the market. Killer acquisitions, we've heard so much, especially in the digital markets, where these startup companies would always be acquired by those that have been existing. Why? Those that have been existing sometimes feel threatened that these new companies, in as much as they may lack capital, they are so innovative and they will disrupt the way business has always been done. The best thing is to acquire them even before they reach that level. And competition authorities will not be kind to that. Now, one thing before I go to the actual elements, and I think I've already taken 10 minutes. Before I go to the actual elements, competition law, again, my colleagues, is not just a luxury that should be enjoyed by the Americans that started it in 1889, by the Canadians that followed in 1890, or even by the Europeans. It is actually more important for Africa than anyone else. Why? Those guys have already reached a certain level of development that even when there is an anti-competitive conduct that frustrates markets and disadvantages consumers, the shock may not be as high as is here because they've got so many other companies and consumers can easily run to those other companies. In our part of the world where our markets are very concentrated with very few companies, if they engage in such conduct where they are exploiting consumers, including exploiting governments, the money that is lost therefrom may be so significant relative to our economic levels or development that the consequences are dire. So we need it more, in fact, here, that has been my argument, more than there. And this argument has been supported by Joseph Stiglitz, those of you who may know him. He is a very accomplished economist. He was once a chief economist at the World Bank. He's very well known. He's even, I think, a Nobel laureate in economics. He argued that competition law is not only a luxury to be enjoyed by developed countries, but it is a necessity for all those striving to achieve and develop free, contestable, and democratic markets. Democratic markets means anyone can enter and exist and operate without any hindrances from someone else. And as they grow, consumers benefit and our countries at the end of the day benefit. What are the basic elements of competition law? Competition law has certain basic elements, and I'll go through them. The first one is they look at mergers and acquisitions. They look at restrictive business practices. I'll explain all those things quickly. And they also look at cartels, and I'll quickly explain on those. But before I get to those elements, what you see on the screen there is what we call the Magna Carta of competition laws. Okay, all of us here, most of us here are lawyers. So I know you understand what the Magna Carta means, so I'll not be preaching to the converted. But even in competition law, we have what we call the Magna Carta, which says all categories of agreements, decisions, and concerted practices which have the object or effect of preventing, restricting, or distorting competition to an appreciable extent in the market are hereby declared anti-competitive business conduct and are prohibited. Why do we say this is the Magna Carta? Because every model competition law that you come across will have a provision that talks about this, because this is basically the basis and foundation of the whole competition law. All categories of agreements, whether they are in mergers or horizontal vertical agreements between companies, decisions or concerted practices, whether they are cartels, as long as they have that object or effect of preventing, restricting, or distorting competition to an appreciable extent, are declared anti-competitive and should be prohibited, because if they are not prohibited, they would have the consequences that we have just discussed before. Now, let me go to the elements. Mergers and acquisitions is one of the elements of competition laws. Simply put, mergers and acquisition means two companies or three companies or even more that were operating independently before choose to operate as one. If you go to the Magna Carta, that may become an agreement. For you, the lawyers, an agreement or contracts can be construed where there's what you call a meeting of minds or consensus ad idem. So even in a merger, we may actually construe it as an agreement, a special form of an agreement. If that agreement is distorting competition, it will be prohibited. And in some instances, companies merge because they want to engage in increasing prices, because if they do not merge, they'll be competing amongst themselves, and he who increases the prices will lose consumers to the other. But they may also agree that the best way of evading this legally, if a competition authority will not see this, is to merge and kill competition amongst ourselves so that we increase prices, we stop innovating. It's very expensive to invest in research and development. We don't want to spend. We can easily make money without those hurdles. They can do that. So that's why competition authorities now will sit down to look at the motivation of those measures. Some measures, of course, and a lot of them, they made for purposes of efficiencies. They would want to duplicate certain costs. They would want to avoid the duplication of certain costs. They would want to engage in synergies, for example, so that they become more efficient, they become more competitive, and as a result, they may grow bigger and even employ more people. Those are some of the reasons why we would look at mergers and acquisitions. So lawyers, when we say notify a merger to the commission, we are not just troubling you. We want to make sure that that merger will be in the interest of your people, not to the disadvantage of your people if those companies engage in activities that would have resulted in distortion of competition in the market and hence affect consumers. The next element is what we call restrictive business practices. In restrictive business practices, we have horizontal and vertical agreements. In the horizontal agreements, it is companies operating at the same level. In other words, they are producing similar or the same products, and they choose not to compete and engage in certain agreements, especially cartels, which we call the supreme evil of antitrust. They are called supreme evil of antitrust because there's no justification whatsoever in terms of efficiency and cost saving. The only justification they have is to steal from the public and from our government. Now, this is where companies will say, why should we be selling bread, competing with each other, selling bread at 2 shillings, when if we chose to agree, we can sell bread at 200 shillings and none of us would complain. Why is it that if the Ugandan government has issued a tender for a road construction, and if we are to go for a competitive tender, the amount that the government may pay is $20 million. But if we agree amongst ourselves that let's collude, let's form a cartel so that there's no competition, and we charge the Ugandan government $300 million, and because they have no choice, they will still get that contract, and we will share amongst ourselves much more than the $20 million that one would have gotten. Those things happen, and governments in most cases have suffered and lost much money that could have been used for other social economic sectors like health and education. Competition laws are saying we don't want that because it frustrates the development of our economies and our nations. The other element will be the vertical agreements, which are not anti-competitive per se. Okay, and when I use the word per se in this context means those that are anti-competitive per se, once they are established, there is no justification whatsoever. There's no justification. They should be penalized and that conduct should be stopped. But for vertical agreements, sometimes there are justifications, and vertical agreements, I'll give you an example. Coca-Cola. Coca-Cola may be saying, our Coca-Cola products, you distributors that we are using, you will not sell our Coca-Cola products at a price higher than 20 shillings. We will say, no, this is bad because you are not giving freedom to the distributors to sell their Coca-Cola, which will bring in more competition. But Coca-Cola will come and tell us that, do you know that we are protecting the consumer because we've set what is called the maximum price. So these guys should not go beyond that. So for verticals, they may be anti-competitive in certain instances, but sometimes there may be justifications. Another example would be where Coca-Cola tells its distributors, we call that recommended or resale price maintenance, tells its distributors that you cannot sell below 20 shillings. The commission there will say, no. This is anti-competitive because if these distributors were given the opportunity to determine their own prices, some of these distributors are very efficient. Some of these distributors are not only using their trucks to distribute Coca-Cola, they are also using their trucks to distribute other products, and hence they're able to absorb costs and are able to sell this Coca-Cola below 20 shillings. So if you force them to just sell it at 20 shillings, then you are bringing a disadvantage to the consumers. This is a vertical agreement because Coca-Cola is the manufacturer, so it's on top. The distributor is down, so it in the chain is below. So vertical in that they have a vertical relationship, but we'll say this is anti-competitive. So those are some of the elements that we look at in competition law. And in the interest of time, I think I can now move to the next level. But we have competition laws at national level and competition laws at regional level. Others, even at continental level now, there are those efforts to develop competition laws at the African continental level. Others may ask, why do we need all these? At national level, it is very important to have competition laws. And Bridget, Uganda, the Commercial Competition Commission is very proud to say we were largely involved in the coming up of that law. And we are so proud of Uganda because it was one of those giants on the continents that did not have a competition law. It was an outlier. We are very proud. A number of, if not all of our member states now have competition laws with the exception of Somalia, I think, and Eritrea. So 19 out of 21, all of them now have competition laws, which is very good. We need to have systems of competition laws at national level so that when we have anti-competitive conduct that threatens the growth of those economies individually as an economy at national level, they should be addressed by those national competition authorities, not regional competition authorities, because the national competition authorities are well and and best placed to understand the behavior of those companies and the nature and structure of their markets. However, if the issue becomes broader and it's regional, that it is not only Uganda that is being affected by the conduct of this company, but Kenya too. No matter how Kenya may want to ensure that that conduct is resolved effectively and efficiently in Kenya, they will be just firefighting. They will not effectively resolve it because it is emanating from Uganda, where they do not have jurisdiction because the Kenyan law is jurisdiction ends on the Kenyan borders. So we need that law that will come and say, oh, we've been given the authority to review conduct or even major transactions that are not only affecting Uganda but Kenya. And then the Commercial Competition Commission and these commercial competition regulations will come in to resolve that issue. That is why we need regional competition regulations, because there are certain matters that go beyond a certain country. So even if that country that is being affected, if it emanated in the other country, would only be doing quick fixes and will not resolve the problem from its roots, because their law cannot have effect in Uganda. But the commercial competition regulations, by the agreement among the member states through the treaty, and the commercial competition regulations will say, if this matter affects Uganda and Kenya, or even all the 21 member states, they cannot resolve it effectively in one country. Let it be resolved collectively as a group or as a community. That is why we need regional competition laws. Now we are going towards continental competition law, because there may also be competition issues that may go beyond COMESA. They affect ECOWAS. They affect CEMAC in Central Africa. How do we deal with those things? It means there is still some layer that is remaining to be resolved. And to bring all those together, we are saying, let us now have a continental competition law that will ensure that if we have this transaction or this anti-competitive practice or this cartel that is affecting all of us at the same time, the best law to address that will be that one, because Zambia, Zimbabwe, or Egypt alone cannot address it. So I hope, again, in the short period of time that I have, you may want to appreciate why we need those regional and continental competition laws. And now, in conclusion, I think I would want now to run to the Commercial Competition Commission itself to just show you some of the statistics that we have and why commercial lawyers should take interest in being part of what I'll just be talking about, because it is the South African lawyers, more than 90%, that has been involved. Commercial lawyers have shared the 10% with lawyers outside the continent from Europe and afar, which is not good. Our lawyers in Commercial should take part of this. If this money that is being paid to lawyers outside COMESA can come to our COMESA lawyers, in principle, we are saying we as lawyers are also contributing to the growth of commerce in Africa, which contributes to our economy, because that money will stay here. Now, so since the enactment of the Commercial Competition Regulations in 2004, the Commission itself was established in 2013. The 9 years of inactivity was as a result of certain administrative and financial challenges. However, it was formed in 2013, and as I said, it became very effective and a fully functional supranational competition authority, at that time only second to the European Commission, the world over. In this time, the Commission has handled over 45 restrictive business practices. Some of them have even issued fines. Those who are following us on our website, we've issued fines on some of these cases because we are of the view that these companies restricted competition in the common market. One of the celebrated cases is that of the Confederation of African Football and Lagade Sports, where they had engaged in an agreement, restrictive agreement amongst themselves that was to last for over 28 years with a possibility of extension, because they were what we call first rights of refusal or preferential renewal clauses. Now, what that did was that the lucrative Confederation of African Football Competition, which sometimes may have tenders of even up to $1.2 billion, were only restricted to this French company Lagardère, and any of our companies in Africa and Comesa at large would not have benefited from that market. So it frustrated the growth of that industry, and you saw that most of us in our countries, we could not watch the AFCON, African Cup of Nations, because it was very expensive. When we broke down or eliminated or prohibited that agreement, we saw a number of other companies entering the field, demonstrating that sector was growing. And all of a sudden, the acquisition of football broadcasting rights became cheaper. The last AFCON, we were proud to say all countries in Africa, not just COMESA, because that decision had ramifications to the rest of the continent, were able to broadcast the African Cup of Nations that took place. Now it's not last year, in 2025, the other year in 2023. That is one of the benefits of competition. And we have also dealt with 55 consumer protection matters. I will not get into the details on that. My colleague, Stephen Kamkama, will be best place to discuss on that, but also 436 mergers and acquisitions. And among those mergers and acquisitions, some of them we've given sweeping undertakings to protect the market, but also the consumer. You can go on our website where you see cases like the Kenya Ports Authority, Kenya National Shipping Liners, and MISC, a private company, which we thought by it merging with the Kenya Ports Authority, it will now have sensitive data about its other competitor shipping companies, and it would use that sensitive data to the detriment of the other shipping companies, which will happen to the detriment of our consumers who are importing goods on those ships, but also to the detriment of our governments. We gave sweeping undertakings in that to make sure that these fears do not arise. Another one which we actually rejected was the transaction involving AkzoNobel and Kansai Plascon. In East Africa, you know about those companies. They are also very well known here in Southern Africa. They are the biggest paint manufacturers. With that merger, we were scared that once they merge, a competition between them would virtually be eliminated, and paint, especially premium coatings, premium paint, will become so very expensive because consumers would not have a choice. The choice that was between these two companies that were fierce competitors and very big at that level is being eliminated by this merger. We rejected that merger and saved the consumer and our governments the burden of anti-competitive conduct that was going to come from there. So those are some of the things that we have handled. And in conclusion, Bridget, give me the last 2 minutes, I'll finish. When do the commercial competition regulations apply? You, the lawyers, would want to understand at what point does the Kenya national law apply? At what point do the commercial competition regulations apply? Because of, and pardon me, I seek for lenience and pardon even before I say this, but I'm going to say it because it's historical. Because of ignorance by some lawyers and the market before. When we started in 2013, and I've seen Bridget is laughing because she knows there's no conflict between the European competition law at that level, regional level, and the German competition law, because they look at different sets of conduct where they have jurisdiction. But because of that ignorance, when we started in 2013, there was serious opposition as to whether the commercial competition regulations were usurping the jurisdiction of national competition authorities. To the contrary, no. Things that are wholly national have up to this time remained to be undertaken by national competition authorities. As I said, they are the best placed because they even understand those markets better. Where the commercial competition regulations come in is where the Zambian competition law will be inadequate to address that concern for its own people. We dealt with an issue here in Malawi, where a Zambian company, and Malawi and Zambia are neighbors, a Zambian company was exporting to Malawi. And that product it was bringing to Malawi injured some consumers here. Malawi has a consumer law, but the product was not coming from Malawi. So in as much as Malawi consumer law may come and say, this is a bad and ultimately we have to be realistic, is they would not address the issue effectively. So the commercial competition regulations were invoked, and Zambian traders were brought under our jurisdiction to address the Malawian concern. And the Malawian consumer was was compensated for that, and that Zambian company changed the way it was doing that business and the products it was supplying, in that it improved quality. So the commercial competition regulation will only come in where there is a cross-border impact involving 2 or more member states. Where it is just a Kenyan issue, it is very clear will never come in. But even where 2 or more member states are concerned, sometimes we don't come in. Remember at the beginning in the Magna Carta, I told you that we only engage in conduct that is likely to appreciably restrict or prevent competition. So even if it's cross-border, but if it's not showing an appreciable nature at regional level, we leave it to the nations to deal with it. And what amounts to appreciability also is being determined in the regulations through the amount of business that the company derives collectively in the common market. Okay. So the commercial competition regulations will only come in where 2 or more countries are involved, and where certain thresholds are met. If these 2 factors are not met, then the commercial competition commission regulations will not come in. And we are on record that we've referred some of these cases, transactions, or even anti-competitive conduct to our national competition authorities. Alike, because now national competition authorities have understood exactly how the relationship is between them and us. When they've realized the matter they are dealing with has cross-border effects, they've also brought those cases to us. So we have now reached a level where there is proper coordination and cooperation between us and national competition authorities. We've had situations like that from Kenya. We've had situations like that from Zambia, situations like that from Eswatini, and a number of other countries that I may not immediately remember here. So colleagues, in the interest of time, and I think EALS, please invite me one day for a full lecture of competition law, because there's a lot to be told. I've just parroted so that I motivate your interest in the subject. I would be very glad to be invited at one point where we'll have a full day discussing competition matters. Thank you very much for affording us this opportunity, and looking forward to our continued interaction. Thank you.
Thank you so much, Doctor. That we haven't done justice to those slides. I could see them flipping over, and honestly, if only I was a magician to stop the time, I wanted to listen more and more. But what is clear from your discussion is that the jurisdiction has been clarified. National authorities don't have to worry, nor do the national lawyers have to worry. There is enough room for everyone. The second thing also that you have ably done is to create a desire, a burning desire for us as lawyers to get interested in competition law. You've given us the statistics of what the South Africans are doing and how we leave this work to the foreign lawyers. I'm sure my colleagues on this call and the rest of the media that we are live on will take in interest, and they will draw out your expertise. In the same spirit, I want to encourage everyone who is participating to please type their questions. There is a Q&A. If you look at your screen, there is a Q&A slot. Kindly type your questions. I will look at that. Maybe at the end of the discussions, the presentations, we will have an opportunity to ask questions. But for now, we are going to utilize the Q&A model. Ladies and gentlemen, we yet have another bespoke speaker, Senior Counsel Fiona Wall. If you're from Uganda, she needs little introduction. She was the former president of Uganda Law Society. Senior Counsel Fiona Wall is the current executive director of Fidelis Leadership Institute, an accredited institution by the CCC to train competition law and consumer protection in Uganda. Senior Counsel Fiona has also participated in private sector input to the Competition Act of Uganda. Ladies and gentlemen, like Dr. Mweba has just told us, that Uganda enacted its Competition Act in April 2024. So this gives us a lot of opportunity as lawyers. Take off time to read it, to study it, and to reach out to people with expertise like Senior Counsel Fiona Wall. She's also the president of Uganda Law Society. She's the managing partner of Nambasa and Company Advocates, and more recently chaired the East African Law Society Conference in Uganda in November, which hosted the first competition law panel of this nature in East Africa. So ladies and gentlemen, please join me in welcoming Senior Counsel Fiona Wall to present to us and take us through some of the competition aspects that she has expertise on. Thank you.
Thank you very much, Bridget. Can you hear me?
Loud and clear.
Okay, thank you. Let me just share my presentation. Start with that. And then do that. Go here and there. Can you see my screen? Can you hear me, Bridget? One more check.
Yes, we can. Yeah, yes, we can see your screen. We can hear you. You can start. Thank you.
Okay, thank you very much. Thank you, Bridget, for the good introduction. Thank you, East African Law Society, for giving us an opportunity for this very important conversation and for inviting me. And I would like to also thank our patron, Dr. Willard Mwemba. He's the patron of the Fidelis Leadership Institute in his other capacity, and the members of the CCC for being here with us. And he has made it very easy. It is very hard to speak after him, but I'm just really supposed to talk about some recent developments since Dr. Willard has said everything competition. So looking at global perspective on what has happened, we've had, remember that we're talking about consumer protection and competition regulation. It's not just law per se, but there's a direct linkage, and I think Dr. Willard also spoke to that. And developments in this consumer protection have been, of course, directly driven by innovation, and they highlight a global trend towards strengthening competition and consumer protection laws. I think you've heard about how, and Bridget talked about this, in Europe, there's a growing recognition that robust consumer protection laws can drive innovation. And we always argue that competition regulation exists to ensure consumer protection. So in light of that, when it comes to consumer protection, recent developments have seen, of course, you know what e-commerce has done to the world, and efforts have intensified at the European Commission to increase accountability for e-commerce platforms for the sale of hazardous items. You can no longer claim, I think we've seen some of these problems with what happened with Jumia. You can no longer claim that you're just a channel, but there's increased responsibility for consumer protection on even e-commerce platforms. We've had, this is also due to a broader strategy to address the influx of low value imports. We've had a lot of dumping, I think you've seen that, and especially for electronic products, and a lot of consumer problems. And in the European Union, I think this is being taken very seriously. When we look at Australia, it's calling for banking competition reform. Specifically, the chair of the Australian Competition and Consumer Protection has advocated, and I think right now they're actually trying to go into a reform process for the legislation. And these reforms include mandatory customer notifications for interest rate changes, enhanced comparison tools. I think if Uganda also used this, and our Bank of Uganda regulator, our bank regulators in Africa, I think this is also something they can take on, because these changes and these calls for reforms are aimed at addressing challenges related to transparency and consumer engagement. We've seen a lot of unfair competition when the big banks cartel together to influence legislation that will kick out local or small banks. I think customers and complainants have talked about for instance, the capitalization requirements in the East African region. They don't seem to be favoring local banks. So this is something, this kind of legislation reform would probably also help in the East African region. The US has made many initiatives to combat junk fees and protect consumers. This is a requirement really to simplify subscription cancellations. If you usually, when you subscribe to something like LinkedIn, or they'll keep taking your money, but should you want to, unsubscribe or pull out, they make it really, really hard. And I'm not talking about LinkedIn, I'm just giving an example. So the US administration has taken steps to protect consumers from deceptive practices that target junk fees. There's a lot of funny fees associated with subscriptions and financial services. The Consumer Financial Protection Bureau has proposed rules to regulate data brokers, because also data brokers take a lot of money. Someone was complaining, for instance, I'll just give an example. If you get maybe on one of these electronic platforms of Momo or Airtel, you find that the fees sort of differ from from what you would use in the USSD code. So these are the kind of things that that the US administration, especially the Consumer Financial Protection Bureau, has taken into consideration. When we come to East Africa's competition and consumer protection laws, East Africa has seen significant developments, and I thank our patron for speaking to that very effectively. But I'll just give a few perspectives. East African community in general is actively promoting regional harmonization of the protection laws. One thing that hasn't come out is that, for instance, in Uganda, it's the Ministry of Trade that is supposed to regulate. So we'll have, I think, a technical committee in the Ministry of Trade. That's what our act envisages, while Kenya, Tanzania, and other countries within the region, for instance, have independent commissions. So this sometimes cause issues of consolidation, comparison, and I think that the East African community is really working at this, especially the East African Community Competition Authority. International cooperation is being promoted, and of course, everything COMESA has been spoken to effectively. We've talked about the Competition Act 2023. It's now called actually the Competition Act 2024, passed in April. Sorry for that issue. It provides a unified national framework, as we've all talked about, especially in prohibiting anti-competitive practices, focusing on consumer welfare, and one of the significant things is that it will promote economic growth, because when it fosters fair competition, manages the economic bullies through looking at mergers and acquisitions to prevent negative dominant practices, protecting consumers, especially giving them a voice and giving them access to competitive markets, and then aligning with regional trends. Because I'm very happy to say that now we're fully plugged in. Uganda was country number 18 of the 21 COMESA countries to get on board. So we're not really at the tail end of this progress. So this is the significance of the act for Uganda. Are there still questions? Yes, there'll be some questions because the regulations, I think, are being, we as a Fidelis Institute, we also participated in helping with the regulation drafting and everything, but we are still waiting for the regulations. And I'm sure that they will address some of the issues that were coming out, especially for private sector regarding representation. Recent policy updates we have in Rwanda, September 2023, approving a revised consumer protection and competition policy. and it was really the major issue around the amendment was to integrate national priorities, regional and international commitments, as well as emerging trends like digital markets and green investment. It's focused on promoting competition. It's focused on promoting competition, enhancing consumer protection, strengthening legal and institutional arrangements, education and enforcement. And one of the other things we need to see also is that with the African Union, the SCFTA protocol, competition protocol, it's also brought in a need for alignment with African countries. Burundi is also working to operationalize its Competition and Consumer Protection Commission. The Comoros is also trying to to implement their act and make sure that it's activated. And then DR Congo is also being looked into and being supported to make sure that they align. And I think that the fact that DR Congo has just come into the ESC, this need for alignment is going to help even countries like Southern Sudan. So it's envisaged that the East African Competition Commission will soon adopt an ex-ante merger control regime and become fully operational in respect of all areas of competition law enforcement. And I'm glad to say that the CCC is a godfather in this process, if I may say so, Dr. Willard. Regional issues, generally, we've had amendments to existing competition in the last 2 years. Legislation, this is for CIMAC, Egypt, that's the Economic and Monetary Community of Central Africa. We've had the Competition Authority of Egypt, Malawi, Morocco, and Zambia, which were adopted they were adopted into the Economic and Monetary Community of Central Africa. And the competition legislation there is being amended. The South African community, of course, including ECOWAS, along with Kenya and Tanzania in particular, they're also amending their regulations to align. And it is proposed that the Competition Act in various countries, including Eswatini, Namibia, and Zimbabwe, which are members of SADC, be repealed, and a draft competition bill for each of these countries be enacted, and they're at various stages. So these are the different recent policy updates. Of course, we know about the SCFTA competition protocol, and it provides for the establishment of a continental competition regulator and adopts a hard law approach to competition law enforcement on the continent. This will mean a lot of we expect more than just COMESA. I must say that in the whole continent, really, it's COMESA that has had the largest success when it comes to making sure that there's regulation in place in its member countries. So with the SCFTA protocol, we hope that other countries will get on board. So I won't say much about COMESA, but the powers of COMESA will be expanded, especially with increased participation by member countries, especially those that have been named that are not yet on board. Now, case law, recent case law, some of it is not very recent because sometimes these cases take a long time, but there's a growing focus. What are the trends in case law? There's a growing focus on investigating and prosecuting cartels in East Africa, with authorities like COMESA actively pursuing cases of price fixing, market allocation, and bid rigging. We also have merger control issues that have arisen. There's increased scrutiny on mergers and acquisitions that may have anti-competitive effects in the region, and authorities are reviewing mergers to ensure they do not harm competition or consumer welfare. Consumer protection cases are on the rise, and I think Dr. Willard said they've handled 55 so far, and I think that they're going to grow. The more, for instance, lawyers are aware of what is happening, I think we'll have a lot more cases coming up, a lot more people fighting for their rights on issues like e-commerce, digital services, and financial products. So just maybe two important cases that I thought have sent waves across. There's the Fair Competition Commission versus Vodacom and Airtel. This was in Tanzania, where they were investigated for charging excessive fees on mobile money transactions. They found that the high fees were harming consumers. If you understand mobile money and what it does for economic empowerment, especially to our grandmothers in the villages, this was a big problem. There's a lot of exploitative prices. There's a huge impact on financial inclusion, and we're looking at also, they were looking at the role of competition regulation in protecting vulnerable populations. They ordered Vodacom and Airtel to reduce their fees, making mobile money services more affordable for Tanzanians. This case highlights the intersection of competition regulation and financial inclusion in Africa. In our East African countries, in our dreams for the SCFTA, we look at issues of financial inclusion. We look at issues of consumer protection. And I think that this is a very important case that can be used, especially lawyers that are here, as a precedent to advocate for fair fees when it comes to mobile money transactions, or even fintech fees. It's similar to the European Union issue on fees, on junk fees. Now, in Egypt, the Competition Authority of Egypt versus Uber and Karim. Uber and Karim is like a version of Uber that's active in Egypt. So they were working on a merger, and Uber acquired Karim in a 3.1 billion deal. The Competition Authority reviewed the merger to assess its impact on competition in the ride-hailing market. Concerns were raised that the merger would create a monopoly, reduce consumer choice, and lead to higher prices. I think Ugandans here will testify that when Uber had when Uber came to Uganda, there's a point at which Uber drivers were negotiating and dictating prices because they felt that they were the monopoly. Now with competition, this has ceased. So the issues that were raised in that particular case was the potential to monopolize the ride-hailing market, the impact it would have on drivers and passengers, barriers to entry for new competitors. Because of course, when you have such a huge giant, sometimes even influence policy and bar entry. Outcomes, what happened? The Competition Authority approved the merger, but imposed conditions. And I think Dr. Willard was very clear when he said they've reviewed a lot of mergers and given very, very direct and intentional conditions to ensure fair competition, such as requiring, in Egypt, they required Uber to maintain transparent pricing and not engage in exclusive agreements with drivers. You see why when a driver has an exclusive agreement, they will not go to safe border. And I think this is a very important case that we can use as a precedent and persuasively in other jurisdictions. Case law, again, key takeaways. When we look at some of the two cases I've talked about, I just picked on those particular ones because they have resounding issues that are affecting all our economies in this region. The key takeaways I'd look at is that digital markets are a growing focus, and African competition authorities are increasingly targeting tech companies and digital platforms for anti-competitive practices. Why? It's because this is now a huge driver for financial inclusion, but it can also be a huge driver for financial exploitation. And also because our traditional bank and financial regulators are still playing catch up with digitech and digital finance, that we're now looking to organizations like the COMESA Competition Commission and our competition authorities to drive innovation when it comes to regulating digital markets. Consumer welfare is very central, and we have seen that, and we applaud, for instance, the CCC, that they are really keeping consumer welfare central to all these cases, because they focus on protecting consumers from high prices, from being excluded, from poor service and lack of choice, and also a lack of accountability from service providers. We also want to say that regional collaboration is key. bodies like COMESA and ECOWAS are playing a critical role in harmonizing competition policies across borders. So we need to also understand, especially lawyers in the East African countries, that as you are advising your governments, even the attorneys general, that if you're advising your governments on how to deal with competition regulation, let's not think in a box. Let's think regionally, because the national decisions and the regional decisions have to be related. So we need to make sure that we harmonize regulation, we harmonize implementation, and we're very quick to even be flexible when it comes to amendments. Enforcement challenges are remaining. And I think, again, when I talk about silo thinking, I must really say this, it will not be very popular, but I think that the passing of our act, our competition act, was a bit one of those where we sort of thought as a country with our issues on rationalization, and therefore we're not going to have an independent authority. And I don't know what that will do for enforcement and other things. And I hope that the decisions of the technical committee will not be questioned in that way. I hope I'm not giving lawyers ideas here, but those are some of the challenges that remain. We have limited resources and expertise, and that's why the Fidelis Leadership Institute is partnering with the CCC to ensure that every lawyer in the East African region is trained. I want to thank the East African Law Society for also giving us this platform. So continuing with challenges and opportunities, there's an opportunity for lawyers as we struggle to implement. I think you saw the drama that happened around October. That was the deadline for Uganda to pass its regulations according to the Act. The regulations, I think, now are being drafted, so that will also cause some issues on how to pass this very quickly. So lawyers are needed to ensure that implementation is done well, to advise, but also to advocate for proper implementation. It should not just be dotting I's and trying to tick boxes. It should be effective, and it should be based on benchmarks and also the supervision of the regional bodies. The success of policies, regulations, and laws is dependent on their effective implementation. For instance, the East African Competition Authority will continue to struggle with quorum if the other new East African countries that have come in do not send representatives there. These are some of the challenges we'll continue to deal with. Building capacity is very important, and I said Fidelis is one of those. So if you're a lawyer out there, we do have courses, and we are going to be running a lot of programs, including a competition law conference this year. So we'll give you all that information. Regional harmonization is very important. We need efforts to harmonize competition and consumer protection laws across our regions. And we can no longer think only in the economic blocks, because we are now chasing the SCFTA. So harmonization has to happen in that effect. Capacity building, I talked about that, but more importantly, we need to also build the capacity of regulators. We need to build the capacity, because now you see also the authorities that are going to be doing the work of competition authorities in different countries. So if you have a technical committee at the ministry, and then you have UCC that has been dealing with competition issues in the telecom industry, for instance, in Uganda, we will need to equip we will need to train and equip and build the capacity of the technical committee. So we have to train the staff, we have to develop expertise, and in-house counsel here are very important because they'll be responding and defending their organizations as mergers and acquisitions increase. Digital markets, addressing the challenges posed by digital markets. And I think this is an opportunity for young lawyers to get into this space. This is your space. It's something that you're really good at, and I think you need to read more about digital platforms, cross-border data flows. How do we support our regulators, our authorities, but also how do we advise our clients to better handle this progress? Consumer awareness, raising consumer awareness of their rights and how to seek redress is essential. I want to also announce that at the East African Law Society conference, we informed everybody that we had also launched the East African Competition Law Network, Competition Law and Consumer Protection Network, and some of you signed up. So those of you that are interested in signing up, you can just send an email to ed@fidelisinstitute.org. Our patron is Honorable Kadaga, who's the Minister for East African Affairs, right? Honorable. And I want to thank East African Law Society, Bridget, and I hope that I have been able to take you through the recent progressions in competition, regulation, and consumer protection. Thank you very much.
Thank you so much, Senior Counsel. Indeed, it's been presented by the Senior Counsel herself. We are now up to date with the policy trends, case law of what is happening in competition and consumer protection regime. It's also presented us the challenges and opportunities for lawyers who are already advanced in practice, but also for the young lawyers, and concluded with an opportunity for everyone to get more training in competition and consumer protection laws. Honestly, I don't know why you wouldn't take up this opportunity. I'll be signing up myself. There's also an opportunity to be part of the East African Competition and Consumer Protection. So personally, Senior Counsel, I am signing up with everyone that I know. So thank you so much. Thank you so much for this opportunity and opening our minds to other opportunities of practice other than just land transfers. So I'd like to thank you and also kindly request you to mute if possible. The members are requesting for the email address. If someone can kindly type it into the chat, and then we'll be able to share it with those who want to join the membership. Thank you. Members, I hope you're still there. I'm excited. We're still 212. Please share the link with a colleague. We've only had 2 presentations. We still have 2 more to go. They would benefit greatly from the presentations. And I'd also continue to encourage you to type your questions in the Q&A chat. I know that most of you are active in the webinar chat, but we may miss your question. Kindly utilize the Q&A chat to ensure that we do not miss your question. All right. And next is Joel Amenya Omari. Joel is a public sector legal counsel with over 15 years experience. He is an advocate of the High Court of Kenya, a commissioner of oath, and a certified public secretary. Mr. Omari currently serves as the Director of Competition and Consumer Protection at the Competition Authority of Kenya. He has previously served as the Corporation Secretary and Manager, Legal Services at the Competition Authority of Kenya. He was the head of legal division at the Witness Protection Agency of Kenya. He was also a senior prosecution counsel in the Office of the Director of Public Prosecution and a state counsel of the Office of the Attorney General. He holds a bachelor's degree in law from the University of Nairobi, a postgraduate diploma in law from Kenya School of Law, and a master's degree in competition law from Brussels School of Competition, Belgium. Ladies and gentlemen, advocates, please join me in welcoming Mr. Omari to take us through the next session.
Thank you, Bridget, for that very nice introduction. Just confirm you can hear me.
Yes, sir, we can hear you.
Just allow me a minute to share my presentation.
Most definitely.
Right.
And yes, we can see. Yes, we
can. You can see my screen?
Yes, sir.
All right, thank you. So just allow me a minute to thank the East Africa Law Society for the opportunity to speak to colleagues this afternoon. so then we can have a few minutes to share experiences on the implementation of our competition and consumer protection law. Pretty much of what I wanted to share with colleagues this afternoon has been covered in Dr. Mwemba's presentation and Senior Counsel's presentation. So I'll try as much as possible not to repeat what has been said. I wanted to speak to colleagues on the aspect of the enforcement of competition and consumer protection law, and we will be sharing with you our experience from the Competition Authority of Kenya as a national competition authority. This is the outline of what I intend to share with colleagues this afternoon. Just a brief introduction, and then also look at key aspects of competition law. The concerns we have, from the perspective of the Competition Authority of Kenya as a national competition agency, and then look a bit on the cooperation aspects, how as a national competition authority we've been cooperating with both the East Africa Competition Authority and the COMESA Competition Commission. Then also end the presentation by looking at really what should be then the role of the advocate or the role of a counsel in all this. Competition law exists to promote competition. We also exist to make sure that anti-competitive practices in the markets are addressed. And this is done mainly for the purpose of making sure that consumers get the full benefit of competition law, and businesses also can operate in an environment that remains free and fair, so that then, as Dr. Mwemba mentioned in his presentation, so then we democratize markets. Business can come in or can exit the market, and it should always remain possible for businesses to keep coming in and exiting depending on the competition that prevails in the market. And that is what remains the prime objective, so that then consumers are able to get the full benefit of competition. The innovation remains, and the motivation to provide efficiencies and pass on those efficiencies to the ultimate consumer. And then also to make sure that those that are able to establish themselves as dominant players in the market, do not, play in a manner that disadvantages the smaller players, or make it impossible for the small players to enter and compete in these markets. These are the key aspects of competition law. I know we are at different levels of competition law enforcement within the East Africa community. But then I thought I should mention that at least for a jurisdiction to have a fully functional competition law enforcement system, I know Uganda has recently enacted their law, but then in addition to the law, you probably also need an agency, or you also need a government department responsible for implementation of that law. You also need an appeals mechanism. In most cases, decisions would be made either administratively, or there will be maybe a prosecution system for the implementation of this competition law. So an appeals mechanism is critical, so that then whoever is likely to be negatively affected by a decision of a competition decision maker knows beforehand that their decision would, the decision made against them is still subject to an appeal before a tribunal or a court of law that is well versed with competition law principles, and that they can actually get redress expeditiously. And then the fourth and most important component is also the aspect of advocacy and education. So that then if you have a competition law, a competition agency, and an appeal mechanism to review the decisions of that competition agency, there also should be an advocacy and education a mechanism or system that ensures that there is continuous education to all the stakeholders, be they advocates, be they businesses, be they consumers, be they consumer organizations, and all that. Advocacy and education of all these stakeholders remains a very important aspect. And it is through this education and advocacy then that people are able to know when to submit complaints to the regulator or when to present their complaints if it's a case of consumer violations. These are really the key aspects. You must have a system for developing and advancing competition and consumer protection policy, and with that comes also the need for continuous research and then the dissemination of information on competition and consumer protection, so as to influence or further entrench the policy. These four others had been mentioned in the first presentation, that there has to be a system for redressing restrictive business practices, and then in our case we have the unique component of regulating abuse of buyer power. Then, of course, generally the regulation of mergers and acquisitions, as well as consumer welfare. I'll not go into detail because I know Dr. Mwemba did this component a lot of justice. So with these key aspects of regulation, we need to also maybe familiarize ourselves with international level, the regulatory pathways that exist, whether it is on matters of policy and research, and how do we originate these inquiries and studies? How then do these inquiries and studies feed into the industry practices, both on market structure and the economic trends that exist? And then how do these findings of our inquiries and studies, how do these influence our approaches in both advocacy and the policy recommendations that are made to the policymakers? The other alternative or pathway is usually through the investigation and penalization, which is what competition law requires and enables competition agencies to do. Like in the case of the Competition Authority of Kenya, there exists two pathways, which is the first pathway of an administrative investigation, which means then that if it's a case of restrictive business practices, the authority is empowered by law to launch an investigation. And then this investigation would be to assess whether there has been a violation or a violation of the law. And if a violation of the law is established, then the authority can go ahead and give restraint orders, give remedies, penalties, and a number of other commitments that are provided for in the law. The issue of the criminal option, I would want to hear what the experience is in other East African community jurisdictions. But in the case of the Republic of Kenya, there still exists the option of pursuing competition law violations as criminal cases, which means then that the authority could investigate and refer these cases to the Office of the Director of Public Prosecutions, who will then open a prosecution for violation of competition law or consumer protection provisions within the Competition Act, which will then, of course, as is the case in prosecution cases, would result in conviction, fines, or worst case scenario, imprisonment. This is a pathway, a law enforcement pathway that exists in our law, although we rarely use it, but it's still part of an option that we have as a national competition agency. Maybe to also mention the process. Out of these three, the administrative investigation is the most utilized process. The authority, on a day-to-day basis, is investigating cases administratively and issuing remedies and sanctions. And periodically, we do conduct market research. I thought I should also share the overview of how an administrative investigation flows from the point of initiation all the way to the appeal process. The authority could start an investigation out of complaint or on its own motion, and would then proceed to issue a notice of investigation to a party that is under investigation. For an advocate, this is usually the stage at which your client will reach out to you once they've been issued with a notice of investigation, which is the formal notification by the National Competition Agency that the party is under investigation. And the notice would require, ideally, that the undertaking that is under investigation should respond to this notice of investigation, giving the information that has been required in that notice, and in some cases also being required to provide the details that help the authority in furtherance of that investigation. Having listened to the party that is under investigation and the information that they give, the authority will then issue a notice of proposed decision, which is an opportunity then for the party under investigation to formally respond to the accusations that have been made against it. They could make written representations and also choose to make an oral representation. With the consideration of the written representations and the oral representations that are made, then a decision is made, which could come in the form of a penalty together with remedies that the party under investigation is required to comply with. Having received this decision, a party under investigation retains the right to appeal to the competition tribunal, which is the appeal mechanism that I mentioned, which then also still gives them an opportunity to appeal as a form of a final appeal to the High Court of Kenya. So that is how the process of administrative investigation flows from the point of the notice of investigation all the way to the appeal processes. Yes, the challenges that we've observed from a national competition agency perspective, and we've seen in the recent days an increase in anti-competitive practices that have a regional angle. You'd see investigations that we conduct at the national competition agency level, which have a regional angle. You would investigate a company within the Republic of Kenya that also has operations in Uganda and probably Rwanda. And that raises the dilemma in the sense that an investigation within the Republic of Kenya alone might not necessarily fully address the conduct, because if for instance an undertaking is investigated and penalized within the Republic of Kenya, but then the same conduct continues in Tanzania and Uganda, that will still not have addressed the issue, which then requires that national competition agencies have to, in most cases, then consider opportunities to collaborate either with the East Africa Competition Authority or with the COMESA Competition Commission. I know with respect to anti-competitive businesses, and from the numbers that were presented by the first presenter, we've not done very many cases, about 50 or so cases, if my memory serves me right. So there's still an opportunity because I know, based on the statistics that exist at national level, there is more that can be done both at the East Africa community level and also at the COMESA level in terms of national competition agencies working together with the regional competition agencies to make sure that cross-border competition violations are addressed instead of national competition agencies, just addressing competition concerns within their jurisdiction. It will make a greater impact if we were to cooperate to address these issues from a regional perspective. Of course, there's also the other aspect of digital markets. Increasingly, markets, are going digital, which means then that the aspect of national jurisdiction remains a limitation. It becomes difficult, for instance, for the Competition Authority of Kenya to be able to investigate and sanction a competition agency to investigate and sanction an enterprise that operates from outside Kenya. If its conduct or if its products result in violation of maybe consumer rights within Kenya. Again, this is also an opportunity where to address fully competition and consumer protection concerns across digital markets, there will be need for both the national competition agencies and the regional competition agencies to collaborate to make sure that we can have a regional approach towards addressing concerns that are both concerns of both of a competitive nature and consumer protection nature that we have seen in the digital markets. Then there's also the aspect of law awareness. I must admit there's still a very low level of awareness in terms of competition law obligations, even among advocates. And I would challenge colleagues that we need to take an interest in competition law as a developing area. The view that advocates have the potential of entrenching competition law and promoting compliance with competition law if you were to enhance the knowledge of your clients and their obligation to comply with the competition and consumer protection obligations. So these are the obligations that are on national competition agencies. Kenya is a member of both the EAC and COMESA. And that means then that we have an obligation to give effect to the principles of regional competition regulation that exist in these two regimes, and to also abide by the rules and also commit to promote cooperation dealing with anti-competitive practices in our jurisdiction. This means then that as a competition agency or as a national competition agency, close and constant liaison between the Competition Authority of Kenya and regional competition agencies is something of a priority, and we have to play our role in making sure that regional competition agencies are able to function and are able to implement their international law obligations within our jurisdiction. Remember, the East African Competition Agency or the COMESA Competition Commission will have it very difficult to work if it doesn't get the cooperation of the national competition agencies. And the national competition agencies, as designated by the rules, are the competent authorities that are able to facilitate the work of these regional competition agencies. These are just a few of the cooperation aspects that I thought I should mention to colleagues this afternoon. For instance, the COMESA competition rules require that the National Competition Authority of Kenya should cooperate with the COMESA Competition Commission locating and securing evidence and voluntary compliance with requests for information. If, for instance, the Regional Competition Agency was investigating a case in Kenya, then it is the responsibility of the National Competition Agency, to facilitate the Regional Competition Agency to be able to do what it ought to do. Then another aspect is with respect to the exchange of information. If in the course of our investigation, we come across information that we are of the view would help in the investigation of an anti-competitive practice that has a regional angle, we remain obligated to exchange this information with the Regional Competition Agency so that then we are able to facilitate them to enforce the regulations at an international level. And once an investigation at an international level has been concluded or has been progressed to the point of imposing sanctions and remedies, again implementation of the sanctions and remedies again remains an obligation on the part of the national competition agencies. In the sense then that we remain obligated to help the implementation of these sanctions within the territory of the National Competition Agency. And what is the role of Council in all this? In the investigation and implementation of the enforcement remedies that arise from the investigation, the parties that are in the investigation are always under the advice of counsel, and therefore, the responsibility to advise and give legal guidance to parties that are under investigation remains the responsibility of the council, and also, of course, to facilitate cooperation between jurisdictions. Remember, while national competition agencies are under obligation to render assistance to the regional competition agencies, they can only do so to the extent that is compatible with the respective competition laws of that particular jurisdiction. And this is where then we come in as advocates to make sure that if at one point your client finds themselves the subject of an investigation by a competition authority, be it a national competition authority or a regional competition authority, you have a role to play, and it's not just limited to making sure that you defend your client to the best possible extent, but then to also make sure that your advice and your facilitation of the client is also geared towards facilitation of the proper functioning of the international competition law enforcement system that exists. I want to leave it at that. Thank you so much for the opportunity.
Thank you so much, Mr. Omari. This has been very insightful, and for me as a lawyer as well, I imagine myself facing a panel of interviewers trying to get a job in-house at the regulatory authority. Honestly, I am just going to take your notes. I'll just take your notes and appear to be an expert. For countries like Uganda, we are copying and following behind Kenyan authority. So we are grateful for the insights on the different things that you've told us, the aspects that are required of a national law, the components of the authority, how it operates, the regulatory pathways, the overview of the administrative investigation. This has been very insightful, and you didn't stop at that. Even for the advocates in private practice, you've showed us when and how will be relevant to our client, especially after getting a notice of investigation, and how we can actually advise our clients. This has just been a tip of the iceberg, but has really triggered us to find out more and more of what we can do, even at a national level. So thank you so much. We are grateful. And last but not least, we are going to listen to none other than Mr. Stephen Kamkama. Mr. Stephen Kamkama is a manager, Consumer Welfare and Advocacy Division at the COMESA Competition Commission. And I think most of you heard Senior Counsel Fiona Wall talking about CCC. Just for clarification, that's the COMESA Competition Commission. He has been there from 2021 to date. Previously, he served as a Principal Commercial Officer and Minister under the Ministry of Trade and Industries Cooperative. I assume this is Uganda from 2008 to 2020. He was a program specialist for trade capacity enhancement program in Uganda between 2006 and 2007. He also worked as a trade specialist in Uganda, looking out specifically for the Uganda trade opportunities and policies between 2003 to 2006. He started off as an assistant manager at Simba Telecom, managing MTN sub-dealer department. He holds a master's in international business, a bachelor's degree in economics, and a diploma in trade policy development and analysis. Ladies and gentlemen, advocates from whatever jurisdiction across East Africa, please help me welcome Mr. Stephen Kamkama. Mr. Kamkama, we're not able to hear you.
Yes, just a moment, just a moment. The CEO is, wants to say something. Okay. Good afternoon, ladies and gentlemen. Can you hear me?
Yes, sir, we can hear you. We can see your slides. Just kindly put them in slide mode so that we're able to get a better view.
Okay. Thank you so much. Are you able to view it now in slide mode?
Perfectly. Thank you, sir.
Okay. Yes, you've introduced me, and thanks for the intro. Meanwhile, Osibiotia or Wasiwota, if we have to go local.
Turije.
And habari za mchana for those that are not may not understand the Ugandan language. So we'll be looking at an overview on consumer protection law, and I will take you through on the background on consumer protection. Why do we need consumer protection? The definition of who is the consumer, and then we'll look at the scope of the law. Finally, I will be able to take you through some of the examples of the cases that the Commission has handled. Now, if we go to the background, in as far as consumer protection is concerned, this started way back 1962 when President John Kennedy presented the Consumer Rights Bill, where he presented 4 consumer rights: the right to safety, the right to be informed, the right to be heard, and the right to choose. Later on, under the United Nations, the consumer protection guidelines were developed in 1995. And then in 2015, they were revised to include additional 4 rights. And these include the right to satisfaction of basic needs, the right to redress, the right to consumer education, and the right to live in a healthy environment. Now, we'll be seeing then what all these, how do they come in, but we'll continue for now to see why do we need consumer protection. When we are involved in the market, in the transaction process, as consumers, we face certain costs and also risks and losses. Now, some of the costs which we face are not direct. For the supplier, the price they know about the price, and that is the immediate cost that we as consumers will pay to the supplier. But there are other hidden costs which we face as consumers. For example, maintaining the equipment, whichever asset you bought. There's a cost of maintaining such an asset. There's a cost on energy if you're going to use the asset. There's a cost on its efficiency. If it is inefficient, you will be incurring additional costs. And there's also a cost related to searching for those goods and services. Now, also, there are risks associated with the goods which we buy. Some goods or services may be unsafe, and some of them could injure us as consumers. They could damage some of our properties, and some of them do not even serve the purpose for which they were produced. And those that try, they are inefficient. So in that regard, it is important that consumers are protected and they are helped to minimize the risks and costs associated with the goods in the market. You may wish to note that consumers are never part of the process of production. They don't know what happens there in the factory, and therefore they cannot be able to understand the ingredients and the purpose for which a product has been produced. So if we then don't come up with liabilities against the supplier, we may be risking the consumer, because the supplier may bring in the market anything they think they like, they want to sell. We have had experts like Collins who indicate that some individuals in the market may even try to exploit consumers with unfair contracts. Epstein also mentions that the market is not as effective, as efficient as we think. It tends to be inefficient. And at that point, the private right of contracts may not necessarily be helpful. And so there may be need to have a law in place to protect consumers. You may also want to say, okay, but we have other laws like the national standards laws. We also have professional regulatory laws. We also have sale of goods laws. We have as many other laws, which the financial laws, you may say, but are they not effective? No, they are not. Why? Because in most cases, they are one-sided. They do not provide, for example, guarantees to a consumer. They do not empower the consumer to enforce the law itself. One of the entry points of the consumer protection law is to empower the consumer to be able to enforce the law while the consumer is in the market, which the other laws do not provide. These laws do not also provide dispute settlement mechanism for the consumer in the event that they are aggrieved in the market. The laws, they regulate in most cases that point of transaction, but as we may see later, consumers get challenges with whatever they bought much later after they purchase the product. And at that point, the law may no longer be available to address that problem, especially these other laws. So if we are considering consumer protection, we need to understand the entry point that it comes in to address those gaps which are not addressed within the other laws. So we cross to what we have under the commercial competition law. We do have provisions which prohibit misleading representation, prohibit unconscionable conduct, sale of defective and unsafe products. And then we are mandated as a commission to impose a recall in case there are unsafe products supplied in the market. You may wish to note that the chief executive officer in the morning, right after in the afternoon, indicated that we come in as the commission when the case affects 2 or more member states. Same cases which we are mentioning here, false or misleading representation and unconscionable conduct, supply of unsafe products would also still happen at the national level. But if they are happening at the national level without a regional scope, then the national authority would handle such a case. When the matter spans across 2 or more member states, then the Commercial Competition Commission comes in to address that. How do we define a consumer? A consumer is defined as that person who purchases or offers to purchase goods otherwise than for the purpose of resale. So what it means here, it is this person who is the final consumer who buys to go and use the product at home for whatever reason, but their product should never get back into the commerce, into the market until it is used up. And if it ever comes back, then it comes as a used item. Then the consumer is also defined as any person to whom a service is rendered. This consumer can be a person, an individual person, a natural person, or can be a legal person, which can be a company or any organization. So we mentioned that the law prohibits misleading representation. So here we'll be going slightly deep into some of the aspects of misleading representation. You may have misleading representation on the price. And again, due to time limitations, I will not go through so much in all these, but you may need to see that, to note that some of the companies, they can provide and advertise that they have promotions where they have discounts, when actually those discounts do not exist. You will reach into a supermarket and you will see that the price has been reduced, and you are happy that the price has been reduced, but you may find that yesterday it was the same price. There are misleading representations that the goods are new when actually they are not new. Misleading representation on the legal status where they show that the product is approved by the National Bureau of Standards, or that the product is approved by a certain prominent person in the country in order to associate that product with such a person, when that information is not correct. There could be misleading representation on the purpose, on the usage, on the standard characteristics of the product, when such information is not correct. And that extends to aspects like greenwashing. We know these days there's climate change challenges, and people would want to show us that the products they have comply with the requirements of the environmental requirements, when actually it's not true. We've seen in most of the in East Africa, you will see the bottles, the plastic bottles. They will be indicating that those bottles are recyclable, that you can recycle such bottles. But a company which says that and does not have any process of picking such a product from the consumers, because the product is already, the bottle is already in the consumers, but there is no process of picking such a bottle back to the company, or there is no factory in Uganda or in Kenya or in any of the EAC countries that is actually recycling the bottle. So just saying that it is recyclable would also be misleading. So there are those aspects of misleading which are so specific. You indicate that the product can solve a certain problem. It's a drug, it can heal when it cannot heal. All those would become misleading. We have fine prints, footnotes, and qualifications which are put in the contracts, which tend to conflict with the overall message. When such is indicated there, then that creates ambiguity and hides material information, which misleads the consumer in the process of making a decision. We also have products which come in and we get misled on the origin of that product, when actually the product is coming from a different country and we are told that it comes from another country, just for us to, in order for the supplier to make sure that we buy the product because of the advantages that accrue from that country that is alleging. However, you will find that that product comes from a different country, and people will also be knowing that such a country has products which are substandard. There is disparaging, where suppliers tend to advertise and show that the products they have are the best. They have the best products, they perform the best, they are the most efficient than any other product in the market. When that is not true, that becomes a misleading aspect. We also have what we call bait and switch, whereby a company would advertise calling for consumers to come and purchase a particular product when actually they don't have that product. And when the consumers come, they tend to push them to buy another product, which they say serves the same purpose. But in so doing, they make consumers get involved in a transaction they would not have wished to get involved in, or to give out information, personal information, which they would not have given out if they had known that that product is not available. So some of the examples that the Commission has dealt with in as far as misleading representation is concerned include one which my CEO mentioned, Boom Paste, which we worked on, which had a challenge in as far as the glass. Okay, this product would, when exposed to temperatures below 15, it would crystallize and form grasses within it. While that would happen, when you looked at the label, we found that the label was not guiding properly the consumers, because grasses would become risky and could harm consumers, especially those that were using the product for washing dishes. So we intervened on this. The product was coming from Zambia and it was being distributed across in Malawi, in Zimbabwe, in DRC, and we intervened, and the supplier changed the way of doing business and put the proper labels and guided consumers on how to efficiently use the product. There are many cases. We'll share the slides, so I will just go to unconscionable conduct. The law prohibits unconscionable conduct. Unconscionable conduct. I'm getting some notice here about internet. I hope you are able to hear me.
Yes, we can hear you.
Oh, okay. So unconscionable conduct is prohibited under the law. Unconscionable conduct is a conduct that in power of the consumer. It is that conduct that is particularly harsh, is oppressive, it's against the norms of society. It's not done in good faith. Sometimes it's deliberate, it's clear and fair. And most importantly, it's such a conduct that is done by the company, but it is not reasonably necessary to protect its legitimate interest. Now, for lawyers, I'm speaking to you when you know this. Me, I'm not a lawyer. You know unconscionable conduct much better than me. But in consumer protection, it is prohibited for any supplier to engage in a conduct that is all circumstances unconscionable. And we have some examples of what you would call an unconscionable conduct. For example, where someone drafts a contract and uses such unfamiliar language with such complex words which are not normally used. They are not used in the ordinary drafting of contracts. And the intention in there would be to hide material information from the consumer. And in that case, if that is indicated and we discover that this word has been used and it is not a normal ordinary word, then in that regard, we would consider such a word. If it holds material information or impact on the contract, then we would consider that to be unconscionable. And is also using undue influence. Some suppliers can use some tactics against the consumer. You have heard of complaints against the airlines where, for example, you appear at the airport and then they announce the delay, and the delay is for 1 hour. Then after 45 minutes, they announce again another 1 hour, another 1 hour. And before you know it, you have spent 6 hours at the airport. In so doing, they are avoiding certain obligations, but they are using certain unfair tactics, which we now consider as an unconscionable conduct. When drafting the contract, you will find that some supplier will not explain or disclose certain important terms, or even include them in the contract, or hide them somewhere in the footnote, in other aspects, in such in a manner that the consumer will not be able to pick such crucial information. If that is done, we'll consider that as unconscionable. So there are many other examples. There's also not allowing sufficient time the consumer to read, review the draft contract and consult a lawyer to be able to understand the details of the specifics in the agreement, so that by the time they sign, they are comfortable with the agreement. If those are not available, if consumers are not given enough time to consult, to negotiate, then we can say that there was an unconscionable conduct. Now, we have a number of unconscionable conducts that we've been looking at as the commission. We had a case of Ethiopian Airlines whereby they delivered passenger baggage which were damaged, and some of their properties had been lost. And when they compensated, they did not compensate some of the passengers on grounds that they had perishable, valuable, and delicate items in the bags which were not allowed in checked-in baggages. But when we checked their laws, the terms and conditions, we checked the terms and conditions of the industry, we discovered that this was not correct, this was not right. And when we investigated, Ethiopian Airlines agreed, and they compensated the passengers. We have had so many cases. You can see in the airline industry, we've had with Airlink, which forced passengers to rebook midway in their okay, in the case of this, in the case of Airlink, the passenger was coming from Eswatini going to Zimbabwe, to Zambia, but then this passenger delayed, the Airlink itself delayed to settle from Eswatini, but then the passenger was conditioned to rebook and pay for additional costs in order to get a new connection ticket from Johannesburg to Zimbabwe, to Zambia. We investigated, and then we were able to address the issue. So there are many. I will not go through each of these, but as we give you the presentations, you could go through them. And if you want more information, we'll be available to provide more information. One of the most recent one, which is still trending, and you'll be hearing much more about it, is Uber, because Uber, in its terms and conditions, it was disclaiming liability for the actions of the third parties. And in their definition of third parties, that definition included the drivers, their own drivers. They were considered as third parties. And what that meant was that if you ordered a Uber vehicle and the driver came, and then the vehicle is in poor mechanical condition, and possibly you got an accident, Uber was disclaiming that it's not responsible for that, because that is the contract you have between you and the driver. But when we investigated, we established that there is no such a contract between the driver and the passenger. Actually, the contract exists between the passenger and the Uber, and therefore it is Uber that is liable for the actions of the drivers. We have engaged them. They also had indicated that the national law is not applicable in case of any dispute. Instead, it is the Netherlands law that would be applicable. So meaning that all our people within the ESC, in the event that you had a problem with Uber service, then you would have to travel to Netherlands in order to have your issue addressed. Anyway, we intervened, and we recently got a decision, and Uber has complied, and recently it has been sending out information that it is amending its terms and conditions. Okay, let's proceed. I've skipped some of the other examples. Then now I go to supply of unsafe products, which are prohibited under Part 5 of the Commercial Competition Regulations. Here, suppliers are prohibited from supplying products that are unsafe, all products which don't comply with standards, both the product and the information on the product. They are required to ensure that the products conform with the standards, and the information which they put on the products also conforms to the standards. Where the Commission gets to know that there is a product in the market which is not safe, which is defective, the Commission can impose a recall, and would also inform the public that there is a product in the market and this product is risky. And of course, we will now liaise with the company and condition the company to recall the product. Those powers are given to the Commission under Article 33 and Article 30 of the regulations. And we've been engaging and involved in so much. We have had recalls, so many of them. Here you may see Bronstone, Maxton, and Carolite Cosmetics. These ones, that was in 2021. They contain hydroquinone, which is a very dangerous chemical. And this is mainly for ladies, so you may need to be careful about this product. We have had Dark and Lovely recently, which this one was just simply a batch issue, but in that batch there was a bacteria that reduces immunity. We also had falsified Ozempic. This is a drug which was in the market, but it was not an original drug, and this one was falsified. So we intervened and created awareness and also alerted authorities so that it is removed from the market. We also had Forte Taka airbags. These are airbags which were in most of the cars, all brands, and these airbags would on their own burst out and create accidents. And as you can see, about 38 people have died because of that. So we created awareness, and we also asked member states to check and see if there are any of such products so that they can be removed from the market. Okay, so I skip all this and go to the liability that there is a supplier who supplies such a product would be liable. And if such a product causes loss or injury to a consumer, then this supplier is liable, and the consumer can seek compensation from any court with jurisdiction. And then when this supplier supplies such a product and we are not able to get the manufacturer who manufactured such a product, then whoever supplied the product will be the one liable. And the commission can impose up to 10% of the total turnover to the supplier if the supplier is found liable for supplying unsafe products. Okay, I'm coming to the end. I'm just leaving you with this quote: effective consumer protection is a fuel for the well-being and better quality of life. It enables consumers to make informed choices, compares supply of variety, quality, safe, and fit for purpose goods and services, while ensuring fair treatment of consumers in the market. Thank you so much.
Thank you so much, Mr. Kamkama. I appreciate the amount of information you have to share, and I'd like to thank the participants for hanging on tight. You know, you'd pay for this, and the fact that it's available to us freely, we are grateful. So participants, I would like to indulge you for another 10 minutes for Q&A. You never know, you could learn something from someone's question. Please stay with us. I know we're losing most of you, but kindly, if you can give us another 5 to 10 minutes, we'll be quick about it. Some of the questions that were asked were for the CEO of CCC, but I know that the panelists we have are competent and able to respond. So kindly indulge us in accepting the responses from all the panelists because they are qualified. So the first question was to do with the current trends, and I think this will go to Senior Counsel Fiona. Do we see a global competition law in place, or coming in place, given the nature of trade that is happening, the digital trade, and the fact that boundaries are becoming invisible? Or are we at the moment focusing on only the regional collaborations, and regulations. Senior Counsel?
And members, yes. Thank you, Bridget and members. As I said before, competition law, competition regulation, consumer protection, it's a global issue. However, we have been regulating it according to the silos within which we work. So we'll see that the regional, it really started at the regional economic community, at the regional block level, where we had, I think the EU has been the one that has had a lot of advancements around antitrust law. But what we are seeing now is that it's moving away from just continental issues to different issues. We have competition law at the ICC level, we have International Chamber of Commerce level, we have competition regulation, now authorities that are grouping up. As I said before, the SCFTA now has a competition protocol, and they envisage that there'll be a continental authority. So eventually also the continental authorities will have, because you see multinationals cross continents, and with digitization especially, it's now a continent, it's now a global issue, and the world has become very, very small. So yes, this is the natural progression of what we expect. That's why a lot of laws now are standardized. You'll find that what we have in our African competition protocol is the same, is almost the same as what they have at the EU, as what they have in Australia and any other continent.
All right, thank you so much. The next question goes to Mr. Omari. And Lillian asks, does the Kenyan system allow for an appeal above the High Court?
I think the clarification to be made is that there are only two appeals. The first appeal to the Competition Tribunal, and then a final appeal to the High Court. There is no opportunity for an appeal beyond the High Court. Once the High Court makes its decision, that is final.
All right, so the other questions are really to do with whether the slides can be shared with the participants and a request for the slides to be shared. And very many votes of appreciations are coming through from our participants. And with this, without further ado, allow me to hand over to the East African Law Society to close us off. Participants, thank you. Panelists, we are so grateful for the wealth of information that has been shared. Gabriel, over to you.
Wow, wow, wow. Thank you so much, Bridget, and our esteemed panelists. Thank you all for joining us today. A special shout out and vote of thanks to you, expert speakers, for your valuable insights on competition and consumer protection law. Indeed, today, your knowledge has enhanced our understanding of this essential area of practice. Like Dr. Mwemba said, it is an opportunity for us lawyers to grow and expand our horizon beyond what we usually practice. To you, our participants, indeed, your active engagement throughout this session has been a testament of your interest in this very pertinent subject matter. Your involvement has indeed made this session very interactive and enriching, and we hope the information that that has been shared today will be used in your legal practice and help you navigate and advocate for fair business practices and consumer rights. So we want to say thank you. Asante sana. We look forward to future sessions with you all. Next week, we'll be having an interesting set of discussions around effective legal writing. And in particular, we are looking at communication and thought leadership. As lawyers, oftentimes, we may not know how to deliver good or bad news to our clients. And in this webinar session, we'll be exploring effective communication through thought leadership. So we have key industry players and titans that we have brought from across the continent. So please register when you see that webinar flyer coming out. Also, we do have a very important discussion that will be spearheaded by our bar leaders. And the discussion this time is, do you know what the East Africa Law Society is? Do you know what benefits you get from being a member of the ELS, and what the future of ELS looks like? So that discussion will be happening on the 13th of February. So we look forward to seeing you all. For now, we would like to wish you a very, very lovely evening. And be sure that we'll share with you the presentation slides and the recording of the session, as well as certificates of attendance and a certificate of appreciation to you, our esteemed panelists. So I would like to thank you. Thank you so much, Bridget. Thank you, Stephen. Thank you, Mr. Omari. Thank you, Senior Counsel Wall, Dr. Mwemba, and Alexia, who has not been on this, who has been following keenly, for putting this together. And we look forward to having a physical interaction. Our inbox has been filled with requests to have a physical in-depth training on this, and we'll discuss with our partners, Fidelis Institute, the COMESA, and the Competition Authority of Kenya, to see that we organize a physical engagement very soon. And that said, from us to you, have yourselves a very lovely afternoon until we meet again. Goodbye.